woman who is requesting for divorce must demonstrate some way that she is being harmed. So harm is generally considered as a man or a husband failing to provide for his wife, for his home, for his children, failing to provide maintenance, or has been violent in some way. Recent amendments to Article 117 and Article 118 of the Personal Status Law, Federal Law Number 8 of 2019, states that the women who are filing for divorce have restricted ability to file for the divorce, since these new amendments have given the court the right to reject a divorce application. So we've seen people who are going through divorce has an impact on children, and we've seen people acting selfishly, especially when it comes to custody or guardianship. So Sharia law thinks differently in terms of divorce. They have given different and equal rights to both the mother and father. So would you like to add something on that?
Yeah, in relation to child custody, custody is the reaction of what marriage and divorce is. So people act selfish. They doesn't think about the children or the welfare of them. They just act selfish on their part, and they claim for custody and guardianship. The Arabic term for custody is hidana, and the term for guardianship is wilayat. So the term hadana, the literal meaning of the term hadana is nursing or nurturing. So it is the mother who has to take care of the child from her upbringing. She feeds him with the breast milk, and it is her duty to make him grow in a well-educated society. So the custody always remains with the mother. So according to the Federal Law Number 28 of 2005 on personal status, the biological mother of the child is the custodian and father is the guardian. The custody involves the day-to-day activity of the child, including her day-to-day activities like this is usually granted to the mother without interfering with the right of the guardianship awarded to the father. At times, the father is responsible for providing the child financially. He is responsible for providing the shelter, expenses, food, medical care, education, and other necessities. So, custody and guardianship are two separate issues that must be addressed individually, as parents do not share their equal responsibility. That is where separation comes in. Separation is when there is no legal impact on the part. When a person decides to separate from the other, you don't have to go it legally, whereas on divorce or dissolution, the marriage is ended. On separation, the marriage is not ended. The court on divorce always acts in the best interest of the child, and therefore, unless given reasons to believe otherwise, they keep him in physical custody of the mother by being under the guardianship of the father. So the father should be the guardian and the mother should always be the custodian. Article 156 of the Federal Law Number 28 of 2005, which is the Personal Status Law, provides that the child custody under the mother ends. When does it end? It is 13 for a girl child, for a daughter, and 11 for a son. So once the son and daughter attains 13 and 11, it is like the father can claim for the custody thereafter. Article 144 and 143 of the same Act, that is the Personal Status Law, speaks on the custodian must be rational. She should be matured enough to have attained the age of puberty. Should be honest. She should be able to bring up and take care of the child, and should be free from any infectious diseases, and not have been sentenced for crime of any honor. So, if the custody, there are some grounds that the custodian should fulfill. So, like if a mother is a custodian, she should not remarry unless the court thinks that there should be someone to take care of her. And the other thing is like she should have the same religion that the child possesses. If the custodian is the father, then he should have a suitable woman in the house to take care of the child. That is some relatives. Only then the child can be brought up. And he should also follow the same religion of the child. So the mother also has the right to claim the extension of the custody period in their son till their son finishes her education and the daughter remarries. So till that the mother can claim the custody of the child. So in case the mother has to prove that she has been good, if she has to claim this the custody, extension period of custody, she has to prove that she has been good with the child. That is, the education, the merit of the child should be good. The child should be in a good medical condition. The health and mental condition should be fine enough. The father has also the right to claim the guardianship, the custody of the child, of the son, in case he thinks the child, the son is becoming too soft in his nature, that by staying with his mother, so that if he thinks he should need to grow up more, act mature enough in some situation, he can claim the custody of the son in such situation, and it is totally upon the discretion of the court in both the cases. If for the extension of the custody and for the claiming of the custody, both the cases, it is the discretion of the court to decide what to do, who has to have the custody. So would you like to add more on towards this?
I feel like another major key element to know about is travel bans. So when it comes to custody or guardianship, to begin with, a custodian cannot travel with the child without the guardian's approval, and vice versa. So neither can a custodian, neither can a guardian, because they have to seek permission from the other party. So flying with the child or going somewhere with the child without the consent of another parent can also be referred to as child abduction. The parent who is abducting the child can face serious legal actions or consequences for this. So if either parent has concerns of their child going away without their permission, they can prevent this by, issuing or imposing a travel ban on the child from leaving the airport. So if there is a dispute regarding this, and if there is no agreement between the parents, then either parent can refer to the matter to the court. So the UAE courts in majority of these cases allow the custody to the mother, as we've discussed previously. And this is also considering the fact that the child at a younger age needs the care and the attention of the mother the most. Also, pursuant to the UAE laws, for example, if the legal guardian dies, then the guardianship passes to the male heir on the father's side of the family. However, despite this, the courts have the duty to look after the best interest of the child, whatever suits the child in that situation, which is why they are required to handle each case on its own merit. And it's possible for the courts to decide that one parent is to accord both the roles of a legal guardian or a legal custodian. Considering the unique facts of the case, the courts have to make a decision that would be in the best interest of the child. Okay, so in order for a court to challenge the guardianship of the mother, it should be established before the courts that the custodianship must be deemed unfit in some way or the other, in order for a father to challenge the custodianship of his child. In order to prove or establish the fact that the custodian, which is the mother, is unfit, it must be conclusively proven before the courts by presenting evidence or witness testimony. However, despite this, there are specific and certain grounds on which a custody can be challenged, which includes the custodian, which is the mother, not being of sound mind, suffering from any infectious disease, or being sentenced to a serious crime. So these grounds are also specified under Article 146 of subsection 1. It is important to note that the general guidelines of the UAE courts are obligated to take decisions which are again of the best interest of the child. So also, in addition to this, Article 4 of the Federal Law number 3 of 2016 on child rights states the fact that the protection of the child is on his/her best interest and it must be prioritized. So these actions have to be in line with the child's best interest.
So speaking on marriage and divorce, what right does a Muslim woman have on this?
Well, a lot of people don't know this, but a Muslim woman does have rights on the day she is getting married. So one of the most important thing which is given to a lady or to a woman, a Muslim woman, as per Sharia, is meher. So in Islam, meher is an obligation. It is a form of money or possession which is paid to the wife by the groom on the day or on the time of her Islamic marriage. So meher could often be money, it could be anything that is agreed between the bride and his groom. So this could be in the form of jewelry, assets, home goods, furniture, anything that she would want from her husband. So meher is usually and typically specified in the marriage contract upon signing the marriage document. So it could be paid to the bride in parts, or it could be paid to her while she's signing the contract or at the time of dissolution of the marriage. So the main intent of this is to provide financial security to the wife in case of a divorce or in case her husband dies. So there is no specific amount of meher. There is no legal specification that it has to be a certain amount or for a certain period of time. This is upon what the wife or the bride decides for her. So a bride or her family may request money, gold or anything, but this has to be specified on the marriage contract, which is also known as nikah as per Sharia, as per Islam. So it can either be paid to her during the time of her marriage, like the meher, or deferred to a later date. So under Sharia law, the wife has the right to ask for her full meher at the time of her marriage or upon its dissolution. This is totally up to her. And there are other ways other than meher for a woman or for a lady who's getting married to protect her, protect themselves from the impact of traditional Islamic marriage rules that usually or mostly favor men. So one emphasized by many Sharia-based Muslim women's activists is that marriage contract itself, again the nikah. Under established Islamic doctrine, a Muslim marriage contract can include various stipulations that alter the otherwise default rules of Islamic marriage law, which could include the nikah, the contract, stipulation limiting the husband's liability, for example, marrying another woman without her first wife's permission, or it could give her equal rights for divorce, or she could include the amount of maintenance she needs. She could include anything that would protect herself. Again, these clauses or these claims by her wife have to be mentioned on the nikah at the day of her marriage. So it could even specify the wife not expecting to do some household cooking or household chores like cleaning. It reflects the fact that the wife has no Islamic obligation to do the housework. So she can use these things to protect her. Furthermore, a Muslim who wishes to divorce his wife, like the man, in the first instance, they have to go to the process of an arbitration meeting, which is usually arranged by the elders of the couple, so that if there is any chance of reconciliation, it could reach before going to the final process of divorce. If these efforts are failed, then the man sincerely thinks that he cannot live with his wife under one roof harmoniously, then he may divorce his wife either verbally or in writing. So in both cases, it is recommended by Sharia that there has to be 2 witnesses present on the occasion of the pronouncement of such divorce.
Well, where does the idea of iddah come into?
Well, iddah or iddat is a Sharia law, a Sharia rule, but it is also specified under Article 136 of the Personal Status Law 2005. So iddah or iddat is a period a woman usually goes through after the death of her husband or through a divorce, to remove the confusion of paternity in case the fact that she might be pregnant. So the time observed of iddah or iddat depends on the manner which the marriage was dissolved. If the marriage was dissolved during a period where the woman was going through her menstrual cycle, then she is required to serve the iddah or the iddat for a period of 3 menstruation courses. If she is non-menstruating, then she is required to serve the iddah or iddat period for 3 lunar months. In case a woman is pregnant, then her iddah or iddat continues till the delivery of the baby, till the time she has the baby. In case of dissolution of marriage, in case the divorce happens and the husband dies, then the woman has to serve the iddah or the iddat period for 4 lunar months and 10 days. And during the same time, if her husband dies and she is pregnant, she has to serve the iddah or iddat time for 4 lunar months and 10 days or until the delivery, whichever period is earlier. So, under Sharia law, marrying a woman during the period of iddah or iddat is void. They are not allowed, or they do not have the right to remarry unless or until they fulfill or they complete the iddah or the iddat period.
So that was an overview of what marriage, divorce, and the steps related to it. UAE does not differentiate between religion and ethnicity like other legal systems. So there are equal rights for women and men. And in relation to joint custody and divorces and all the proceeding which has been set out in the new guidelines that has been provided by the Abu Dhabi Judicial Department, the new family law will provide a flexible and advanced judicial procedure for the adjudication of the personal status and all the disputes relating to the personal status for non-Muslims.